I shared a case many of the time in my sessions. There was a case where hair removal procedure was done through laser on a lady on 8th sitting, where frequency is increased, leading to burn, skin burn. And this lady went to the consumer fora against the doctor and cosmetic center. And since the consent was very properly taken by the institute, where it is clearly mentioned one of the complications of skin burn, court has observed that lady has read all the things, been informed about all possible complication before going for the surgeries is signed. Court has given judgment in favor of a cosmetic center and doctor. Now you can understand how important consent is. So this is the judgment, a landmark judgment, a judgment of Kusum Kumari, very, very famous judgment in medical negligence. You will find this judgment been cited in every corner in medical negligence cases by the respondent, means by the doctor. It was so much so favorable judgment for the doctor. Because this judgment has given a guidelines for defining and deciding the medical negligence cases. The Honorable Supreme Court has observed that these need to be followed before defining and deciding about any of medical negligence case where compensation is involved. Beautiful judgment. Well protected to the doctors. Plays a vital role in law practice, friend. Beautiful judgment. Like the same judgment, a similar judgment, and today also holding very good is a judgment of a Jacob Matthew of 2005. The judgment was demarcated and clearly defined the criminal medical negligence in medical practice. They have defined the driver versus doctor a negligence, because same section is put on driver also and doctor also. The 304A interpreted the law in so beautiful way. One of the landmark today also, after lapse of 16 years, this holds very, very good when the question of criminal liability comes. And not only that, the judgment very clearly said, till the time government come out with a law, this judgment or these guidelines need to be followed while defining or fastening a criminal liability against the doctor. And the guideline says another 4 ingredient, that educate judges or authorities are not a doctor, being an expert field, medical being expert field, before fastening the criminal liability against the doctor. Every matter of medical negligence must be referred to expert for opinion. And if expert says that proper treatment given, sufficient treatment given, file is closed. But expert says this is just improper treatment given, then case can be registered. So without expert opinion, no case should be registered against the doctor. Second, negligence must be gross. And in gross negligence, they don't not to go for expert opinion. Gross negligence, left mop leading to septicemia and death. Cross-pathy practice, not allowed to do practice, but still patient died because of injection given by cross-pathy doctor. So where it is a gross, you don't need to have expert opinion. Third, it says that police officer, if at all, violates this particular guidelines and register a case, then contempt of petition must be initiated against such a police officer. So strict. But yes, fourth, they have given a freedom that if at all police officer feels there is a chances of tampering of evidence or running away from the law, reason to be noted and police officer can arrest without opinion. But this judgment has really cleared all the doubt in relation to simple medical negligence and gross medical negligence. One of the beautiful judgment ever given in our country which has protected our doctors from criminal liability and been followed in multiple cases. Based on the same, there was another judgment came in Mumbai's case of D'Souza's. The D'Souza's case has again shaken the medical practice because it was in very much favorable judgment for the doctors, cited by doctors in multiple cases where not only criminal case has been protected against the doctor for the criminal liability, but one step ahead, the judgment has gone and said that even in civil cases, the expert opinion need to be asked for, which has really made a hue and cry in a country because consumer got impacted very badly, and followed by another judgment came in Krishna's specialty case, where the judgment of Markandeya D'Souza has been overruled, and that judgment has brought again the same picture that in consumer court, no expert opinion is needed. In criminal court, yes, expert opinion is needed. But judgments, unless been overruled, remains the same. Now, in this case, it has been overruled by another judgment. And second question was that 3 benches judges are always superior to 2 benches judges. Has really changed the horizon. C.P. Kumar's judgment, beautiful observation done on the basis of various judgments passed earlier, protecting doctors in a medical negligence, saying that allegation is possible against anyone, but just the allegation without any evidence, without any proof, denied by opposite party is null and void, cannot stay. A beautiful judgment. I have used this judgment in multiple cases where proper evidence has not been filed by the patient to give a relief to my doctors. The series of judgments in olden time, right from 1995 to 2013 or D'Souza's, further this, have really brought a great change in medical practice, friends. Very recently, on 6th July, if I remember, 6th July 2020, the National Commission, just below Supreme Court, when I talk about consumer fora, has given another judgment in a case of R.G. Stone, has shaken the country in respect to medical practice, friends. Where first time this court has observed that pre-printed consent form, which is across the country used by every medical practitioner, has said the pre-printed consent form having a few blank space for writing something in the place for signing of a patient or a witnesses is high-headedness of the hospital, arbitrariness of the hospital, which is unfair trade practice. And it needs to stop immediately. And further to that, the judgment has penalized the hospital for 10 lakh rupees to be paid to aid committee or deposited to aid committee, law aid committee. But now it has become precedent. It has been challenged. But unless Honorable Supreme Court overrules it, this judgment holds good. Today, if at all pre-printed consent form is used by any of my doctor, it is going to be really tough to defend. So judgments are there to bind the court. Judgments are there to argue the matter. Judgments are there to fill the vacuum of the law. And multiple judgments are there where these judgments have been deferred and future new judgments are coming. Lots of gap has been filled. Lots of things have been argued, discussed on every topic, everything you discuss. there you will find a judgment either of the place of the country. And High Court judgment of any state holds good for lower court in a country. Honorable Supreme Court judgment across the country holds good for lower court. High Court judgment for other High Court definitely helps us, not as a precedent, but definitely helps us for the ratio. So multiple judgment. Like in Maharashtra, if I tell you, when this MD pathologist has filed the case against the DMLT, CMLT, they got the stay. When they presented that without doctor's signature or investigation on a blood, if report is given, it is dangerous for the life of the patient. And that made MD signature mandatory on every pathology report. Been cited various places. Various judgment of radiologists. Various judgment PCB and DTs, and PCP and DT. You can find a good number of judgment. Even the Honorable Supreme Court has observed in one judgment that minor mistakes, writing mistakes, should not be the ground to file criminal cases. The PCP and DT judgment, the organ transplant judgment, MTP Act judgment, really changed the practice. 20 weeks pregnancy, less than 20 weeks with MTP Act can be aborted, but there was a multiple judgment came where more than 20 weeks, court has gone step ahead in such a cases where life abnormalities to the extent to abort the child, compelled Parliament to amend the law of MTP Act to bring it to 24 weeks. IVF, surrogacy, latest technologies. Friends, when court decide the matter, it enlightened the government also. Then the elected representative discuss in the Parliament and that get a color of a new act. Digital Health Act, Telemedicine Act is a new domain in that particular direction. When the need of telemedicine arose in this country during COVID scenario situation, earlier, no one was having a time to look to this matter. But due to COVID, when it was become emergent, social distancing become important, but at the same time, treatment to the patient become important. Finally, the notification was brought by the government to allow a telemedicine practice in this country. And now, Digital Health Act is going to bring a lots of changes in this country when I talk about digital practice in this country. Looking to the development of the country, looking to the growth of the country, looking to the technology development of the country, it is predicted by many of the people that down the line, 5 to 7 years and 10 years, 60 to 70% medical practices of OPD is going to be on telemedicine. Knowing this, friend, it is my personal advice to every colleagues of mine here to adopt this change with immediate effect. If you don't adopt the change, you will be out of the race. You are lucky crowd that you are coming to know about this Telemedicine Act. Adopt it. Start your practice on telemedicine. Start catering 130 crore plus population of this country instead of remaining to 2 lakhs population in local area. Expand your horizon. You can practice wherever you are, at home, on traveling, or anywhere where you need to examine your patient on teleconsultation. 80% work done because prescription you need to upload only after coming to provisional diagnosis. And for provisional diagnosis or confirmed diagnosis, what you need to have is reports, is a history of the patient, is a chief complaint of the patient, which you use in a personal examination. You come to diagnosis. In some cases, where you really wanted to physically examine the patient, and where distance is a factor, you can definitely use health worker, nurses, allied health professionals, or another RMP, registered medical practitioner, who can do your work of physically examining the patient, giving a feedback to you for prescribing the medicine, is one of the beautiful law in this country.